The learning objectives for this lecture are threefold. And unlike last week where we talked more about the functional IT components, we're really going to focus really more on the online components and the criminal functions of cyber law. First, we're going to talk about the role of contracts and online transactions in cyberspace. We're going to identify the cybercrime and tort laws with cyberspace. And then we're going to examine the principles related to governance. And governance is a word that we're going to define in great length within organizations. So let's talk about contract law. What is contract law? It clarifies the relationship between individuals, groups, and organizations. It's formed by two elements: a party who's offering something and accepting something. An accepted offer and terms are binding on both parties. Terms are enforceable in a court of law. So when you think of contract, everyone knows about contract law from buying a house, or when you buy a car. You exchange money, you are the offer, and the offerer goes ahead and purchases something. So think about it as a transaction. You're making a purchase, you're purchasing something, you're the buyer and the seller. Well, that's what a contract basically is. You're the purchaser or the seller. But in a legal sense, it's the offer and the acceptance, but it's a legal document creating that agreement. There can be two kinds of contracts. There could be oral or written contracts. Obviously, when it comes to the law, you're really looking for a written contract. Specific types of contracts must be written down and must be signed. Obviously, you're looking for written contracts to prevent fraud. Like I said, the example of contracts is for selling land as an example. And what you're looking for is contracts that require reciprocity to show there's some kind of exchange in value. Now, when you're looking at the value of a contract, you're looking at three measures. Has something measured complete performance? Is there substantial performance? Or is there incomplete performance? If one party doesn't fulfill all of its promises, there's grounds for breach of contract. So for example, if a person says, I am going to construct a house, or I am going to construct a swimming pool, but they only go ahead and dig the hole for the house, or only dig the hole for the swimming pool, but they don't put the foundation in, they don't put the concrete in, they don't put the walls in, they don't put the tiles in, they don't put the motors in, or the heating system, and everything else that goes there, clearly there's an incomplete performance. Sometimes there's a substantial performance, but the functions of the system may not work. So there's a breach of contract because there are terms that state it shall work a certain way. Complete performance means it's met the complete criteria. So when you buy a home and there's a checklist and everything meets the standards, that's what it's considered complete performance. Tort and criminal law is a little bit different law. Tort is part of civil law. It refers to wrongful acts or harm for which an individual can sue a person who's caused them the harm. It governs disputes between individuals. So one person does something wrong to another. They believe it's something that's going to affect them personally. For example, something is said appropriately. It affects them publicly. That's considered tort law. Follows what is called the reasonable man standard. Criminal law deals with violations against societal norms. Murder is an example of a criminal act. So let's look at tort law from three categories: strict liability, negligence, and intentional. Strict liability is responsible even if no one harm is done to other person. It's basically it happens. There's physical harm, and that's it. So in a car accident, as an example, you hurt somebody in a car accident, you know there's damage. Whoever's the person who has caused the car accident is automatically responsible. That's considered tort law. Negligence, liable for injuries in absence of due care. So once again, negligence is because you've caused that car accident. In absence of due care, you're negligent. Or if you're in front of a store, you slip and fall, and let's say there's oil or butter or something like that, and you didn't clean it up, there's negligence. And intentional shares common elements with a crime. So you were murdered, or you cause fraud because X happened, and it's a combination of negligence or liability. Well, for example, you created a computer system that allowed somebody to rip your bank account off, and as a result of ripping your bank account off, they had access to private information that allowed somebody in your family to be murdered. So, it's a combination of the criminal/tort law component. This is where a combination of laws come together. Cybertorts, combination of things. Torts arising from internet connectivity. So, this is where you think about children who are put in harm because of a predator. That's an example of where cybertorts come into play. Traditional violations of intellectual property rights. Intentional inflictions of emotional distress. A person has bad things said about them on the internet that cause undue stress because of public embarrassment. Harassment can occur in cyberspace. Cyber trespassing. Somebody's bank account has been trespassed, or you have email violations. Someone has accessed your account inappropriately. This is where cybertort law comes into play. Violating the right to privacy. For example, if a person has their camera on their laptop, on, and they have a visual of something, and everyone in the world is able to see it, but no one really knows that camera is on. And there is a large following you in accessing your video in your bedroom or whatever. That's, accessing things in privacy that you're unaware of because someone is spying on you. That's an example where cybertort comes into play. Characteristics of criminal law. Criminal law aims to deter wrongful behavior, punishment for behavior, rehabilitation of the offender. Typical, societal recognizes two basic types of wrongful conduct. Conduct is universally agreed to be wrong or dangerous to others, harming to others, and conduct that is inherently wrong but society prohibits it. Murder, rape, anything that has to do with illegal substances, anything that could harm others or harm to you. Types of wrongful conduct is misdemeanor, that's a minor crime, and there's a felony, which is a more serious crime. Those are the two kind of wrongful conduct criminal acts. Now, in online communication, when you're trying to make purchases online, believe it or not, any single time you make a purchase online, you're essentially creating an online contract, especially when you're creating online subscriptions. Every single time, for example, every time you purchase something on Amazon, you're ultimately creating an online contract that you want to make a purchase. Any single time you submit a form, you're ultimately creating some kind of online contract saying you're willing to provide information to somebody in exchange for a good or service or a product of some sorts. Here's what's considered online contracting. Underlying transactions are the same for online contracts and traditional contracts. Online contracts make transacting businesses a heck of a lot easier. It creates problems for the contracting parties and for the law, and the reason is that traditional law assumes that parties know one another prior to entering into the contract. My question for everybody is, do you think that you know the party on the other side of the online transaction? You go into a store like a retailer, make a purchase. You absolutely know the person. You're at the cash register or the jewelry store or the clothing store. But the person who is going ahead and posting the picture, the person who is pulling the item, the person who is delivering the item, you don't know how many people have touched that item or the person who's made the item. You don't know anybody in the transaction cycle. Not a single person. Not even the person who's processing the transaction or what they're going to do with that information. This is where the online contracting process is a little bit different, and it's a little bit more ambiguous. Contracting over the internet makes it unlikely that they're in the same state, geography, or even country. Even if you're talking to the person on the phone, it's kind of considered online contracting unless you have a communication, a conversation. It's a little bit more challenging, to be honest with you. Online contracting, what is the other challenges? Jurisdiction is an important issue for online contracts because online contracting, if you were to go to a court of law, if you're in the same state, it's a lot easier. If you were to go ahead and try to sue somebody in the online environment, whatever the state is where the company is headquartered or the transaction occurs, it depends upon the corporate entity. So, for example, if you were to go to Amazon's headquartered in the state of Washington, technically, although it is a corporation with an entity in the state of Delaware. So you would have to go to the state of Washington if you were going to sue Amazon. Even though it's a corporate entity in the state of Delaware, you would have to go sue Amazon and go to Washington. The likelihood of anybody suing Amazon is next to nothing. You would usually have to sue one of their partners because most of the merchandise that Amazon sell is through a partner channel. So, the contracting vehicle, as an example there, is understanding your jurisdiction. Who was the purchaser? Who was the party? Where is the jurisdiction where the item is coming from? Or where is the content stored? The contract forms when the offering party receives an acceptance, the agreement, the acknowledgement. People encounter special types of online contracts every day. As soon as you sign, you agree, you would press I acknowledge, or you sign something, or you put your initials, whatever you say I acknowledge, or any kind of, I concur, that's when you're ultimately, accepting the terms and agreement. Clicking on the I agree button without reading or understanding the I agreement, that is ultimately saying that you acknowledge and you are waiving your rights. Common challenge. Less than 1% of people actually do the I agree. So, let's talk more about contracting. Software is the holy grail, as I would say, of online contracting. The average end user license agreement is between 15 to 20 pages. There are a lot of terms and agreements within end user license agreements that have nuances of what you can and cannot do with software. An end user license agreement is a contract between the manufacturer or distribution of a piece of software or a service and the end user of the application. It states how the service or software can be used. Contracts are accepted by removing the cellophane wrap or entering the software by signing in, logging in for the first time, and basically it's a shrink wrap contract. Now, here's the interesting thing. That used to be the way things worked when vendors, software vendors especially, used to distribute DVDs, CDs, and so forth. Now, we're in a services model. Everything's cloud-based. When you agree to the as a service model and you pay your subscription fee, you get your login, you get your password. Every time you log in, you're essentially agreeing to that contract over and over again. They're monitoring you. They know every activity that you're doing. They are tracking you. So because the software is on their system, in effect, it's not something they need to worry about because they're controlling it. If the software was on your system and if it's an infrastructure as a service and you're distributing the software across your organization, and it's a single piece of software distributed to many people, then you're still in that EULA category. But if it's a SaaS model, they don't necessarily have to worry about it. It's just as much as saying you need to participate using our rules and our regulations and behave, appropriately. Don't use it for unorthodox behavior. So EULAs have changed a little bit because it's more of don't do things for criminal intent, because torts aren't so much of a concern in a cloud-based model anymore. So this is where Uniform Electronic Transaction Act comes in. Online or electronic contracts are just as valid as traditional paper-based contracts. The purpose is to remove those barriers to electronic commerce by validating online contracts. Surprisingly, they're adopted by 47 states. There are a couple of states who don't accept them, and it's because, frankly, a lot of regulatory issues within those states. Now, what is cybercrime? I want everyone to read this slide for a second, and then I'm going to go ahead and let everyone pause and tell me what's odd. So what's odd about cybercrime is crimes that use computers. What is a computer? It's an electronic device. It could be a phone. It could be a tablet. It could be a smartwatch now. It could be a laptop. It could be a computer. Heck, it could be a TV. Anything that has some kind of digital transmission is ultimately considered a crime now, as long as it has some kind of internet connection. That's the thing. Cybercrimes are crimes that use some kind of computer technology. 93% of all cybercrimes are associated with data breaches that were linked to organized crime. And organized crimes are fraud, waste, abuse, things of that sort. And a lot of times it's data dumps or data accidents, really. It's not something that occurs by accident. It's usually a system takedown. It's not something that happens. Identity theft and data theft is a multi-billion-dollar industry. It really is. A lot of companies will forego a $1,000, $2,000, $3,000 theft. They'll call it a write-off because it's not a big deal to them. It really becomes a big deal when it becomes a low to medium 5-digit number. Companies call it the cost of doing business. They do. And it's sad because we as consumers are the ones who have to pay for the cost of doing business. But it becomes part of the process, and sometimes it becomes too late. But, federal and state laws are created to address cybercrime, and it's difficult to track the criminals because a lot of times these criminals are able to protect their identities through cloaking activities. They're able to use, fake identities. They're able to use fake IP addresses. They use alternate, mechanisms. They drop their laptops or their devices. They use it one time only. For example, a lot of criminals, when they're committing fraud, they will use Visa gift cards. They're not going to use their own credit card or a check. They're going to use Visa gift cards, disposable check cards. It's eventually trackable. You can track those kind of things because you can tie it back to an IP address, and you can track some things with those items, but it takes a while to figure out, and you have to use things like link analysis software in order to figure out cybercrimes. But that's not for this course. You really have to use threat intelligence capabilities in order to find those that level deep capability. So cybercrime affects everyone. It affects every person that you see in this chart. I'm going to give everybody a second to go ahead and look at this chart. Now let's shift from law to governance. What is governance? Governance is the basis for an organization's information security program. Governance really is recommendations. It's a framework to recommend what is the best way forward. It's a structure by which an organization should follow in order to go ahead and make the greatest good for all the people that work in the organization. That's really is. It's critical for complying with government regulations, industry standards, or local laws and ordinances. It's a framework. So every single time a company wants to go ahead across all of its departments, all its organizations, all of its IT systems, they form governance. So for example, if you want to have all the managers at an insurance company have their employees have a standard set of roles and responsibilities, you create a set of governance for managers, and then directors, and senior directors, and vice presidents. You create information security governance for roles and responsibilities for employees. That's an example of governance. It's the key to success or failure for an organization. It really is. And when it comes to system governance, it's very important. Every organization doesn't have just information security governance. They typically have HR policies. HR policy is a form of governance. Accounting departments have governance on how they manage their financial processes. So information security is just how do you manage your systems? How do you manage your privacy, your security controls, your technology in the grand scheme of your organization's operations? Let's look at it. There's procedures, there's standards, and there's policies. Policies focus on the broad scope. It really changes. Standards, they change over time, but procedures are very specific and change frequently from department to department, organization to organization, group to group, even from person to person. Sometimes it changes from person to person. Policies are high-level document standards for information security goals. They are directions for information security programs and their guidelines that are really meant to be attained. Standards, mandatory activities, actions, rules, and regulations. They support the policies and their specific directions to be put into effect. Procedures are checklist. You shall follow these directions in order for a system to be put in place. If you don't follow this, the system is considered non-compliant. We all know that. Guidelines, they're best practices. No, it's really focused on privacy level. It's not mandatory, but it's guidelines. Departments usually have a lot of guidelines for employees or managers, but procedures are the holy grail. They really are the best practices, and this is what the company must do in order to meet the standards of a lot of regulatory bodies. This is what everybody must follow in order to meet a government agency. Should somebody come in and say, what is that you do in order to meet everybody's rules for a financial institution, if the IRS was to come in, or FEMA, if there was a healthcare or an emergency disaster issue. This is the kind of stuff that's required. Information security policy standards, they should be easy to read and understand. They should be comprehensive, well-defined in scope, clearly address specific aspects of the security program. They should be updated regularly. What is considered regularly? At least 3-4 times a year. And they should be available and communicated to all employees in a central location. What should be part of these recommended security policies? It shouldn't just be about data. It should be about data, network access, data retention, intellectual property. It should be comprehensive. And these are the key 5 areas that should be as part of the information security policies. I'll let you take a minute to go ahead and look at this. So what do online contracts do? What is the behavior of an online contract? What does it regulate? How our product and service can be used? What rights does a consumer have? What is the benefits of the owner or the vendor? and owners can try to sue for breach of contract. So, for example, if you were to purchase a subscription to a piece of software and you were to do a 12-month contract, you pay your subscription fee. You can pay on a monthly basis or a yearly basis. So let's say you were to go ahead and use a cloud service provider. And the cloud service provider says you are not allowed to put any videos that are more than a gigabyte in storage. You are not allowed to go ahead and put any adult content on it. You are not allowed to store any software that is proprietary. And also, you are not allowed to put any government secure information on it. Department of Defense, Department of Justice, any kind of information that is government sensitive. That's part of the contracts. That's limiting the consumer's right. You're an individual consumer. They scan the drive. All of a sudden, they see a red flag. Ding, 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 ding. It's protecting the vendor, because if they were to be audited, they would be the ones fined, not you as the consumer. They have a right to dismiss you as a customer. So online contracts that EULA is what protects them. They can refund you, or they can terminate your contract for non-compliance. That's what an online contract regulates for the behavior. So hopefully you understand the extent of the contract framework. Unique contracts, unique challenges for cybercrime. Sorry for the tongue twister. Cybercrime really does target systems and data. It does. It tries to exploit systems and data more than anything, because data is what you can get, and you can get more information on data, and it then allows you to get data. Data equals money. Money equals be able to go ahead and exploit more data. Computer networks accessing large systems facilitate cybercrime. Nobody's going to want to get into a person's laptop, honestly. If you're going to go ahead and commit a cybercrime, you're going to want to exploit a network. You're not going to target a single computer unless you really know that person and you know there's something very, very important on that computer. You're going to target many computers. It's a many-to-one relationship. One network with many computers, you're going to pull the data back, and eventually something good's going to come out of it. Cybercrime involves new crimes that didn't exist before computers. Honestly, it's reinventing the wheel. It's fraud, but in a different format. New laws are required to address cybercrimes, and honestly, criminals are always ahead of people. They're always ahead of the technology companies. There's always a new kind of cybercrime. So we can control it, but we can, manage it. And that's why there are unique challenges. It's something that is always a challenge, frankly, because you just never know how sophisticated the criminal is. So CFAA, the Computer Fraud and Abuse Act, it focuses on a couple of different components: unauthorized access to security information, unauthorized access to protected computers. If you intentionally transmit malware, viruses, or worms that damage a protected computer, it's considered a crime. If you're unauthorized trafficking of passwords or other computer access information, and you're extorting information involving threats to damage a protected computer, these are all considered criminal acts. Now, the reality is many people, don't intentionally transmit malware, viruses, or worms, and if you do, it's a dime a dozen, but usually it's an accident. Same thing with passwords. You don't intentionally do that kind of stuff unless there really is a purpose. Other federal laws that are very important to know: Theft and Assumption Deterrence Act. It makes identity theft a federal crime. So if you pretend to be someone online that you aren't, that's considered a crime. So for example, if you create a fake email account and then use it online to pretend to be somebody, or you create an account and expose yourself and pretend to impersonate somebody that is a real person, even a fake person, it's kind of considered illegal, especially with with legal government bodies. Electronic Communication Privacy Act governs access to stored electronic communications. It basically says your information is considered private if it's electronically stored based on information that you control. Additional laws controlling the assault of non-solicited pornography and marketing. Now, CAN-SPAM is really about email messages, and to some degree it's about text messages. And it's manifested itself to micro blogging and other platforms. And we're even seeing this with Facebook and Twitter and blogging, because if you get a message that you don't request, or you get a telephone call that you don't request and it's unsolicited, you have a right to block it. And if it's not blocked, or the provider doesn't accept that you don't want the call and they don't take you off, quote unquote, the list, they can be criminally charged. They can be fined. That's where CAN-SPAM comes in. Anti-Cyber Squatting Consumer Protection Act, 1999, designed to stop people from registering domains that are trademarked that belong to other entities. One of the things that you look at is a person's name. Now, there's public, identities, and then there's private identities. So, for example, if someone was to go ahead and be a celebrity named Jack Hyman, they can go ahead and they can sue me. If there was a person named Bob Jones, and there's plenty of Bob Jones in the world, whoever's the most famous Bob Jones can sue the non-Bob Jones and say, hey, I'm the most famous Bob Jones in the world. There are people who have been considered public leaders who have sued private citizens and have sued them, and they've lost in the court of law because, frankly, the information that was on the website didn't have enough burden of proof that it was pertaining to them. It was more about the institution. It was giving generic information. It really has to be a burden of proof that it's harmful to you and it's danger to your life. So, anti-cyber squatting, it really has to be, danger to, and it really has to be a criminal as well as a tort-based act. Creation of security policy. We're coming towards the end. So, security policy should focus business needs with the protection of the information, aligning the information security, the physical authentication and authorization with your business goals. When you're developing information security management systems, you want to focus on the application governance policies. What's the application needs? Based on what the governance policy is, you should think about universally accepted standards, focus on risk-based approaches, focus on evaluating control measures, really. Focus on what is the minimal versus what's the maximum. Review policies and controls to evaluate the need for change. What is it that you're going to need to maintain the status quo? Don't always focus on things that are going to be continually. You don't want to always change things. Make things where you can resist change as much as possible, because changing too much can actually deteriorate the quality of the system. Creation of security process. Create a high-level statement. Establish standards and policies, review standards and policies for compliance, and then establish procedures. This is really the process that you should go through as you're focusing on the authentication and authorization process, building that model for success. I'm going to let you focus on this slide for a second and look at the policy development process. I'll give you 30 seconds. Online contracts really have two roles: the consumer and the end user. The consumer is either the software manufacturer or the website owner. And then the end user really is the licensor. And I use the consumer broadly as the software manufacturer, the website owner, because software manufacturer is the distributor, and the website owner is the one who is distributing the software. And they're the ones who bring together all the pieces, and the end user is the one who's making the purchase. So those are the two parties that come together. Now, when we're talking about roles for information security governance, these are typically the parties that you need to focus on who are involved in creating that governance. I'll let you take a look at this list, and we're going to go in depth for a couple of these people. Okay, information security roles. The board of directors is required by law to act with due care and make the decisions in the best interest for the organization. So, if you're a publicly traded company, there's typically 8 to 10 people who act on behalf of the company and the stockholders to act on behalf of the employees, the executives, to make unanimous decisions. The Chief Information Officer is the most senior technical executive who focuses on the strategic IT issues and defining the IT mission. Chief Information Security Officer is the senior most security official who is responsible for information security strategy and tactical planning. And information security managers are really individual contributors responsible for functional management. They're really running the day-to-day operation for the security programs and the infrastructure. Now, let's talk about special types of contracts in cyberspace that, we haven't covered yet. Contracts of adherence, we've talked about it. I agree, no negotiation, benefits licensor. These are the types of the form. I agree. There's nothing more to it. There's no negotiation. It's either you have to say yes or no, or that's it, or the benefits licensor, there is nothing to it. You're getting something, and there's nothing to it. It's a freebie. And user license agreement, it protects software owners' copyright, so the vendor, and it specifies how the consumer may use the software. So this is typically the traditional proprietary software vendor, and then shrink wrap is when you get a physical copy of the software, and you can download it, but instead you can get it as a paper document, as a text file or a Word document or PDF file. Now, there's something called click wrap and browse wrap. Click wrap is presented to the user when purchasing software or services online. Click wrap says, you must agree. And it's a 4, 5, 6-page document. 9 out of 10 times people don't read it. They just scroll, and they say yes. Some vendors are very smart, and they require the user to click a couple other buttons inside the click wrap in order to say yes. They still don't read it. Maybe 1 or 2% read it. And then browse wrap is terms of use on a web page. You have to accept it, but there's no affirmative action required to accept. You browse, and after like 30 seconds, then the page will go ahead and allow you to move to the next page. So these are types of contracts in cyberspace, but they're really not enforced. People don't read it because they just want to get to the end result. And this is a problem because it's a form of governance, it's a form of law, but less than 1 or 2% of the people actually go ahead and comply with it. Now, functional security policy is great because it protects data, it supports business goals, it adapts to the needs of the organization, it documents, employee responsibilities, and it addresses information security issues. This is what is good about making sure people log in and log out every day. When a person logs into a website as a consumer, it documents all these things as well. This is what authorization authentication does. It logs, it protects the organization. It's always on the side of the vendor. It's always on the side of the employer. It's never on the side of the consumer or the employee. That's the key. The law is always on the side of the corporation. Seldom is it on the side of the consumer or the employee. Okay, let's look at this picture for a second. Big guy, cyberbully, little guy on the computer screen. I think we have the picture. Who's the boss? Mr. Cyberbully. Who's the little man? The employee, on the computer. We covered a lot today. We did. We covered general principles of contract law. We covered cyberspace and online transaction contract information. We covered extensively about end-user license agreements, general principles about criminal law, cybercrime, laws governing cybercrime, high-level policies, information security standards, uses of security guidelines, security procedures, and even information on military and civilian governance of information. How does the government apply laws to some degree, using some of this policy framework versus the consumer? Hopefully you've learned a lot in this lecture, and I thank you for spending so much time listening this week. Thank you.